All right. Well, good morning, everybody. Thanks for joining us this morning. It's the legal issues with bringing employees back to the office during the COVID-19 era. My name is Doug Pickford. I'm the president CEO of the Dulles Area Transportation Association. And for those of you who are not familiar with DATA, as we're referred to, we're a transportation management association. We work with employers to find transportation options for your employees. And with the hopefully going back to normal this year, it will be a challenge, I think, to build the confidence of a lot of your employees in using transit and public transportation. But we are here to assist you in doing that. Our whole objective is to get your employees out of their single occupant vehicle. I'm sure we're going to be doing a number of webinars here in the coming months, but if you would like to reach out to us and get some private consultation or assistance, feel free. We will put our contact information in the chat room. So before we get started, I wanted to reflect on some survey findings that were recently published by the Greater Washington Partnership. They conducted a survey at the beginning of the year that surveyed about 172 employers. It was split about 50-50 between those that had under 50 employees and those that have more than 50 employees. And I guess to summarize it, the question isn't really if employees are coming back to work, it's really more or less when. And the survey found that most employers are looking to probably bring most of their employees back at the end of the summer or in the early fall. So as that is occurring, as great as telework has been during this COVID period, it's interesting, only 1% of the respondents, the employers, said that they would be continuing on a 100% telework basis. The majority of the respondents expected maybe allowing 1 to 2 days per week for their employees to telework. So that's a good sign that the telework option is actually catching on. Another good sign really is that 3 out of 4 of the employers have not altered their real estate or office footprint and don't expect to in the next year. So they are expecting to bring their employees back. I think that's a telltale sign. So before we begin, I'd like to recognize our co-sponsors this morning. The Dulles Regional Chamber of Commerce and the acting CEO there, Joe Martin, had a conflict. He couldn't join us this morning. The Greater Reston Chamber of Commerce and Charles Kapoor. And Charles, if you'd like to say a few words, feel free.
Oh, sure. Thank you, Doug, and good morning, everyone. With the Greater Reston Chamber, we represent a pretty diverse group of business operators throughout the region, from retail solopreneurs all the way up to large employers. Anecdotally, some of the things that I'm hearing, I'm sure, are pretty common to most of the folks that are here on the call, and some of our surveying has shown out. The things that folks are thinking about as they're looking at the prospect of bringing folks back to the workforce. And anecdotally, Doug, I agree that most of the folks that I'm hearing are looking to bring people back in. I think they are looking at maintaining some level of the work from home adaptations that have been brought in over the last year, but certainly not looking for this current state to be the norm. I think it's a measure of productivity and profitability from how much of that you maintain moving forward when we're able to go back to life as normal. But the biggest concerns for most people are, I think, still access to and the cost of maintaining a safe and healthy workplace, access to the cleaning products and equipment that they're going to be required, especially if their place of business engages with clients, not just employees. And then I think the issue of what's the liability for an employer as they're bringing people back in, managing that social distancing space within a workspace. What is the liability of an employer to maintain the wellness of their employee? And is that going to be changing? Does the landscape change for them in this post-COVID era? So I think those are some of the things that I hear about
Yeah.
businesses that we work with.
Great observations, and I think that's exactly what we're going to be touching on this morning. So before we get started and before I introduce our third co-sponsor, I just want to say that we'll be taking questions throughout the webinar. Just put them into the chat box, but we won't address them until after the presentation. But feel free to enter in your questions as we go along. So our third co-sponsor is the law firm of Odin Feldman and Pittleman, and our two presenters obviously work with them, and we're very happy to have them here this morning. It's Sara Sakagami and Marina Blickley, and I'm going to turn it over to you, Sara.
Thanks, Doug. Good morning, everybody. Thanks for having us this morning. As Doug said, I'm a partner at the office of Odin Feldman Pittleman. I concentrate my practice on labor and employment. I do both litigation and counseling from matters relating to anything between discrimination matters to enforcement of restrict covenants to unfair, competition type of litigations, and counseling in matters of like handbook accommodations, also representation in the position statement for any claims filed with the EEOC or Human Rights Office. Marina, I'm gonna.
Can you, just to confirm, can you guys see the presentation now? I've started sharing my screen.
I can.
You can, okay. That's all I see. So thanks for joining us today. We're really happy to be here to talk with you about these issues. As Sara mentioned, we're both employment attorneys at Odin Feldman Pittleman. We've both been practicing about a decade. I've been doing employment since 2008. We've been dealing with COVID issues, obviously, since about this time last year. And we're going to discuss today some of the legal challenges with bringing employees back to work. Feel free to link in, to send Sara or I LinkedIn, connection requests. We tend to post stuff there as it's coming out. It's an easy way to get information out as well. So today, the focus of today's topics are to go over current legal restrictions and requirements here in Virginia, mostly Virginia. Virginia was the first one to come out with workplace safety standards. So we're going to discuss those, and they've been recently updated. So we'll go through some of the legal implications of bringing employees back to work through the COVID-19 pandemic. We'll also discuss practical considerations as well. So, to Charles's point, what is the legal liability? Should we be looking at bringing people in only after they've gotten vaccines? What are other employers doing? What are we hearing from our clients? And it's been changing over time. So kind of go through more of a discussion towards the end. So the first part would be more of a legal discussion. What is the standard of care that we're aware of at this point? What are the current guidelines? And then go through, how do you address bringing people back to work? So with that, I will turn it over to Sara.
So Virginia, as Marina said, was the first state to issue workplace safety standard. It was issued back in July of last year, and it was issued on emergency basis and has recently become a final, effective as of January 27th. All employers in Virginia must comply, and it will continue to be in effect until the Safety and Health Code Board determines that there's no longer a need for the standard. The Safety and Health Code Board is supposed to meet periodically they were supposed to have an initial meeting within 14 days of the governor's emergency order being lifted for COVID. And then after that 14 days period, they would meet periodically to determine whether the standard would be required. So the fact that the emergency order has been lifted does not necessarily mean the standard is no longer going to be in effect. It would continue to be so until the board decides that the pandemic has subsided enough that the standard is no longer necessary. Can you move to the next slide?
Yep.
Marina, thanks. So I'm going to go through the general requirements of the standard. As you start to bring in your employees back to the workplaces, these are the steps you're going to have to take in order to comply with the standard. The first requirement is to conduct a risk assessment on all job tasks and determine what the risk exposures are. Job tasks are not the same as job descriptions or job positions. So one position might have different variety of job tasks that expose them to different level of exposure risks. The differentiations are made into 4 categories: very high, meaning extremely high risk of exposures to the virus, such as conducting the procedures or collecting or handling the specimen of the virus. High risk are those who are exposed to known individuals infected with virus. A lot of the healthcare providers would fall under this category. Medium risk are those that it does not necessarily expose them to the known or suspected to be infected with the virus, but they require more than minimal contact with others within the 6 feet. So the restaurants, transportation, gym, personal care type of workers would fall under this category. And all other employees or job tasks would be considered low risk. That would be mostly those people who are working remotely, be able to work within the confines of their office space that's segregated by the walls, and or at least has a 6 feet distance between the desks.
For most professional workplaces, am I right, Sarah, that there's usually just a few employees that have higher than low risk? We're going to talk about the controls and things that you need to put into place, but it's like people that might be greeting vendors, right? Or the receptionist who has to meet with clients or things like that.
Right, so they would fall under the medium risk, but the others who can go straight to their office and then start working on their desks would usually fall under the low risk category. So that's the first step. Once you do that, you need to establish a system and procedures for employee self-assessment and screening so that they can determine whether they're exhibiting the symptoms of COVID-19, and they can isolate themselves and not come to the office when they're having a temperature of more than 110, 100.9. I think that was the threshold. There's ways the system should also include the way to maintain contact so that the employees who is feeling sick or coughing a lot or have a fever can report to the employer and let them know that they're exhibiting this type of symptoms and be isolated or not coming to work. The second step, and I have on the website, on the presentation up here, the Virginia Department of Health has a guidance on daily screening that you can adjust to your needs, and that would be helpful to you as you consider bringing in the employees back. The third step is implementing the engineering, administrative, and workplace controls to minimize the spread and exposure to virus. So engineering, what does that mean? It means implementing systems or type of protections in place to make sure that you're protecting your employees. Having a plexiglass in front of the receptionist's desk to minimize the direct contact as the receptionists greet the visitors. That's one of the engineering type of controls that you can implement to assist the employee, the receptionist. Other ways to minimize the spread would be to stagger the shifts so that there's less people coming in to cover the office, so that the space within the office place and the number of people within it would be able to easily maintain the 6 feet distance from each other. Make sure that you notify and minimize the use of common area at the office space, so that the lunchroom is not being occupied with 5, 6 people in any given one time. And that would cloud the space, and it would be hard to keep the distance between them. Make sure that you have hand sanitizers in place and spread out throughout the office space, so that they can easily access to those cleaning and disinfecting supplies. Those are some of the type of things that you can implement, that you need to implement in order to make sure that the employees are kept safe.
And the regulations themselves are, what, 52 pages long or something. So it's a pretty detailed regulation by the Virginia OSHA. And so, obviously we're giving you an overview here of the types of things that are required by law in Virginia for employers to do to assess the risk and then implement procedures. But, there's more detail, obviously, that can be put into place, like Sarah's alluding to, as to what specific controls and changes to your workplace need to be implemented in order to alleviate the risk.
And the fourth requirement is the implementation of procedure in case of confirmed or suspected infection. So once an employee tests positive, you need to have in place, the recommendation is probably have a dedicated individuals to, like HR personnel or someone who can be contacted to to be notified of the positive test results or a serious, onset of symptoms, and let them know that they are intending to take the exam, the test, and waiting the results. Once you have been notified of that, there's a notice requirements that's triggered, and that involves notifying the other employees who may have been at the work site at the same time with that infected employee within 2 days before, or and 10 days after the onset of the symptoms. This is a change from the previous emergency standard. Previously, they required for any employees might have been exposed to that infected employee 14 days prior to the onset or the positive test. It has been shortened to 2 days before, but now it requires 10 days after the onset. The notification also, so the notification would be the employees I just covered. That would also include any contractors or the subcontractors or anybody who were at the work site with those infected employees within the same time period as well. When you're notifying the individuals who are suspected or have been exposed, you need to maintain the confidentiality of the employee who has tested positive. If there are more than one employee who has tested positive within the 14-day period, you have to notify the Virginia Department of Health if there's 2 or more. This has been changed. Previously, it was just any time that the employee tests positive, you had to notify the Department of Health, but now it has been changed to 2 or more. And you also have to notify the Department of Labor and Industry if you discover that 3 or more employees have tested positive within the 14-day period. So what it means is that once you receive a first notification of an employee testing positive for COVID-19, start counting that days. And then if you get another notification within the 14-day period, after that, you need to notify the Department of Health. And as you continue to receive notifications, you need to continue to report the infected employees to the Department of Health until you receive a notice from the Department of Health that your outbreak case has been closed.
And this is just to make sure everybody, as you're bringing people back into the work site, obviously, if you receive a report of somebody who's positive, who's been teleworking all along, you don't have an obligation to report that, right, Sara?
That's correct. So this is specific to the employees who are at the work site. So if an employee tests positive and has not been at the work site, then there's no notification requirement.
And for some employers, there's also coordination with the actual building. So if you're in a building that has multiple tenants, you may have already seen reports from your building saying, hey, there was a positive case in the building, because under these guidelines, you also have to coordinate with the building as well if there's a positive case in the building, right?
Right. So another notification that's not listed here is the notification to landlord, and that notification needs to be sent as soon as you receive a notice of a positive test, positively infected employee being at the work site.
Yeah, and at least the clients I've spoken with that have worked with the Department of Health in Virginia or Fairfax, we're here in Fairfax, I feel like they've gotten positive results. They're responsive, they're helpful in trying to assess, what do I do under this circumstance? An employee came in, they were sent home immediately, now they're testing positive, so there's definitely assistance from the Department of Health as well that people can get with how to appropriately respond.
Right, and they have streamlined the notification process, and they now have a portal that the employers can use to notify. So, and that can be accessed through the Department of Labor and Industry website or Department of Health websites. Okay, so the next requirement is to establish a procedure for return to work once an employer has tested positive for COVID and has been isolated. Obviously, if once they are test positive, you can't allow them to come back to work. you have to keep them isolated. But when can they come back to office is what you have to create a procedure or system for that. Previously, they had a systematic or test result standard basis to which the employer can determine whether the employee is eligible to return to work. But now they have changed that, and the requirements, it's a default requirement that all employee needs to be excluded until they are exhibiting no fever for at least 24 hours without the fever reducing medication, has an improvement in respiratory symptoms, and has been at least 10 days has passed since the onset of the symptom. That is for the symptomatic employees. There are some people who do not exhibit any symptoms, even though they have tested positive for COVID-19. And for those employees, you have to wait at least 10 days since the initial positive test result. And I say that without onset, meaning if later on the employee starts exhibiting symptoms, then you need to revert back to the 3 requirement of the symptomatic employees. Some employees who are severely, has exhibited severe illness of COVID or have a immunocompromisation, pre-existing immuno issues, then you might need to require extended isolation. The employer is recommended to consult with infectious disease control experts, and I expect the Department of Health is going to be issuing some additional guidance for that requirement, like how the employers can implement that, or comply with that requirement. At the moment, they have not issued that yet, but this is a new requirement, and we expect that as they bring in more materials and guidance information, that will be part of that. So.
Oh. There, sorry.
So The other requirements are the infectious disease preparedness and response plan. That's not required of all employers. If you have job tasks that's categorized as very high or high exposure, then you have to have the plan regardless of how many employees or how many job tasks that involve that exposure are present. For employers who has a medium job tasks, and it has 11 or more employees, then you have to have a response plan. It's generally recommended to have a response plan in place. It's because, if like you have a receptionist who would be categorized as a medium, exposure risk, then and you have more than 11 employees, like it's good to have this plan anyways, because the response plan also has in place all the things that you already had to do anyways, meaning the plan would involve a designated person to be notified when someone tests positive or is feeling ill. It would have a procedure in place when what type of procedures the employers has implemented to allow the isolated employees to come back to work. So those are already things that you've already have considered under the standard, and you're just putting it into a more of a package plan. So it doesn't require a very extensive burden on the employer. So I generally recommend having the plan in place regardless. The only issue is that the plan, under the standard, if you are required to have one, you have to have one in place by March 26th.
And we'll discuss OSHA too in a few minutes, but OSHA's probably going to come out and require a plan as well. So certainly recommended, and more so going forward.
And we have up here at the bottom a web link to the DOLI's guidance and the training informations, and they actually have a template that you could adopt to create this response plan. So, and then the final requirement is providing training on the hazards and characteristics of virus and COVID-19 disease. This is intended to allow education on employees and how they can monitor or it's intended to expand the knowledge of the employees of the disease so that they can identify when they're feeling ill and what they need to do when they do have an inclination that they have the COVID-19 disease. This training is required of all employers who has any very high or medium job tasks, and the training needs to be provided to all employees, regardless of whether the specific employee is conducting a low job tasks or medium job tasks or high. So if you have, again, it's just like the response plan. If you have any medium level job tasks, then you should go ahead and have that the training done anyways. If you are required to have this training under the standard, then you should have a certification kept on in your files that contains the date the training was provided, that the person who provided the training, and the name and the signature of the attendees or the employees who has attended the training. Again, this training is required to be provided by March 26th. If you have already provided the training, you are probably okay, except that the training also includes training on the response plan, and to the extent that you have adjusted the response plan or have changes that requires to be, since the training has been done previously under the emergency standard, then you should probably conduct a refresher training to be on the safe side. So the standard also has a requirement, or it prohibits discrimination or retaliation against employees who exercise their rights under the standard, or who voluntarily provides or wears protective gear, masks, hand sanitization, anything that they feel safe protecting against the virus, as long as those type of protective gear does not pose health risks or any dangers to that employee or other employees, then you are required to allow them to utilize those. And anyone who raises a reasonable concern about infection control at the work site, and that also includes social media. So anyone who says, takes a picture and posts it on Instagram or Facebook for raising a concern at the work site on the infection control, you cannot discipline them, even though you might go against your social media policy. The failure to comply with the standard does have potential liability risks. It's enforced by Virginia Occupational Safety and Health Department. They can issue a citation with an order of abatement, and once the VOSH finds a violation of the standard. It's pretty high for any serious or below violation. The penalty could be up to $13,000. For willful or repeated violations, it could be up to $130,000. Once the order of abatement has been issued and you fail to comply with the order within the time period allowed to comply with that order, you could be assessed additional penalties for up to $13,000 per day. So it could be a pretty high penalty for a failure to comply with this standard. Again, this standard has been on emergencies basis issued, has taken effect for almost 6 months. And we noticed that in terms of the numbers of, enforcement, VOSH has been taken pretty lenient. It has not been very active in terms of the enforcement issues so far. Marina, can you go to the next page? So based on the publications, we found that they've received 13,000 complaints, but of that, the VOSH has conducted 100 investigations due to serious concerns, and even further down, only 27 employers has been cited for violations. So they have been using this enforcement power pretty sparingly during the emergency standard, but now that the standard has been made final, I imagine that VOSH is going to be a little bit more active in their enforcement of the standard.
Thanks, Sarah. So obviously, Sarah was just talking about the Virginia Workplace Safety Standards by VOSH. Other legal requirements that everyone should keep in mind, obviously, are the governor executive orders. The current order, number 72, is effective through February 28th. It was extended at the end of January because of the high number of COVID cases still. So as of right now, we're still at a modified stay-at-home order with a curfew between 12 and 5 a.m. Telework is encouraged whenever possible. So a lot of employers are still very much in this stage, especially professional employers, right, where you have people that are working on computers and talking on phones, are very much in the telework arena at this point. This will expire, though, at the end of the month. So there are definitely people, our clients have started contacting us again, especially the professional ones, of when are people going back? June was sort of a time frame that I feel like I've heard, and now I'm starting to hear more in the fall as well. But the order currently, gatherings, more than 10 people are prohibited right now in Virginia. That doesn't include employment. That's not considered a gathering. Retail business is not included in that. Religious services are not included in that, and educational instruction. So for purposes of face coverings, this is actually broader than the workplace safety standards in a sense, because the governor's order now says that all employees must wear face coverings while working at the place of employment. And so there's at least in, under the order that even if you're sitting in your office, you have to wear a face covering at this point, because there's no real exception for if you're outside of 6 feet distance. Outdoors, obviously, if you can't maintain the 6 feet, you're required to wear a face mask at this point. Indoors, if you're in a shared space. And then there are some exceptions, right? So if you're eating or drinking, if you need a reasonable accommodation, all employers need to be aware of that as well. But there's exceptions for that under the governor's order. So there's also guidelines for all business sectors that are available on the governor's website. And this has been in place for a while now, and it's being updated fairly regularly. Most recently, it was updated for the masks in the workplace requirement under the Executive Order 72, because that wasn't there previously. It goes through very similar requirements and discussions of physical distancing, still encouraging telework where possible in the workplace. So many employers who have professional workplaces may have a cohort of employees that are going into the office, right? They're IT professionals, one person to check the mail, people to do billing and run payroll, things like that, that maybe can't be done as easily in telework. But where it's possible, it's still encouraged in Virginia to have telework accessible for employees. The guidelines, these are just guidelines. So we went from legal requirement to executive order, which is legal requirement, and then now guidelines of best practices, right? So the best practices for employers, enhanced cleaning and disinfecting, obviously referencing the CDC guidelines, which are also guidelines for reopening. They have a lot of information on their website as well as to especially the cleaning, disinfecting, isolation, and quarantine. And then there's also best practices for enhanced workplace safety. And so since this is a workplace safety talk, I figured we'd go through that a little bit more. It discusses having screening for employees, encouraging sick employees to stay home. If you're going to conduct health checks, looking at how are we going to conduct health checks? Are we just going to have employees self-check? We have a policy that says in the morning, make sure you're checking your temperature. If you have any symptoms, don't come to work. Are you going to have an active form that you require employees to fill out every day? Or on the other side of, are you going to have actual person coming and checking the temperature before somebody comes into the workplace? If you're going to be doing something like that, consider the risk to that person who's taking the temperature of these individuals, because they're going to be exposed to every single person who comes in the door. Most of our employers have opted not to do that. There are certainly employers that are checking temperatures. And if you're going to do that, you need to make sure it's confidential. And there's requirements for that as well. Require face coverings, both nose and mouth at the work site. Engage in flexible sick leave policies. So there was federal sick leave policies that were implemented under the coronavirus FFCRA, the Families First Coronavirus Response Act. Those have now expired. So absent congressional act, there's not a federal requirement for specific coronavirus sick leave. However, if you have sick leave policies, obviously it's encouraged that you allow people to take sick leave for coronavirus related leaves. The guidelines also address having employees self-identify if they're vulnerable, and vulnerable being at a higher risk of serious illness due to exposure to COVID. And that's 65 or over, or having underlying medical conditions. This is where employers often need more guidance on how exactly to address these issues. We have more slides later, but in general, the types of things that you might put into place are offering these individuals ways to change their workplace, right? Minimize the contact. If you're not giving everybody their own office, it might be a reasonable accommodation for somebody at a higher risk to allow them to have a more separate workplace so that they're not as exposed as other people. Maybe allow them to telework more, allow them to have staggering work shifts. So even if you're not offering it to everyone, if somebody's at a more vulnerable position, you might offer that as an accommodation. Also suggested that you have a staff person to contact for COVID concerns. And then if you haven't occupied a building in a long time, there's other safety concerns to be considering. Other things like, is the water safe to drink still? Has the water been going through the pipes? If you're in a large commercial building, you probably don't have these considerations to think about, but it is mentioned if it's been an unoccupied building to make sure it's safe to go back. So up until the new administration, OSHA had been fairly silent, and that was one of the issues that Virginia was trying to address, right? Virginia's Department of Labor and Industry came in and did the workplace safety standards because there wasn't a national workplace safety standards in place at the time. There was CDC guidelines, but not. And OSHA, obviously there's OSHA regulations that apply generally to keep a safe and healthy workplace, but there wasn't specific requirements related to COVID. So OSHA, one of the first executive orders under the Biden administration directed OSHA to implement guidance within 2 weeks, which it did on January 29th, and then also to look at implementing its own emergency standards that are likely to be similar to Virginia's. So the guidance came out, it's available on their website. It is not applicable to healthcare or emergency response, so it's for lower risk employment. And then it says that you should, quote, should implement a COVID-19 prevention program similar to what Sara was describing, and that is the most effective way to mitigate the spread of COVID-19. So it largely tracks Virginia workplace safety standards, looking at hazard assessment, identifying and adopting measures to limit the spread of COVID in the workplace, obviously implementing those measures, and then making sure that you have policies and procedures for what if somebody gets sick in the workplace, or they come, they feel good in the morning, and then they start to feel sick later. What are you going to do to respond to that, to isolate them, make sure they get sent home? And then also has protection against retaliation. There's 16 elements to the program under the OSHA guidance. I've put them all on the slides, but they're largely duplicative of the Virginia workplace safety standards requirements. There were a few things I wanted to point out though. Under 3, implementing controls. There's an actual hierarchy of controls that OSHA describes. So it's sort of from best to worst, right? The best is to eliminate the risk as much as you can. And then it goes down from there. So you can erect barriers, right? If you can't keep people 6 feet apart, then how can you keep them from exposing each other, right? So you might have an actual barrier between those two people. Masks are also lower on the list. Ventilation in the workplace, are you going to have the airflow move more than you used to? Are there certain filters that you might want to put into place? Can you open windows or not? A lot of places can't open windows these days. And then last is, cleaning and disinfecting. And then for number 4, policies and practices to address workers at higher risk for severe illness. I kind of touched on this already, but it's required if somebody has a disability, obviously, to provide them a reasonable accommodation. And that can be for things like mask wearing, but it can also be for actually coming into the workplace. So if there's an accommodation that can be provided, such as telework, that may be reasonable for somebody who's actually protected by, the ADA. So on this side, these are 6 through 10 of the OSHA prevention program key elements: educating, training workers, instructing them to stay home if they're sick or potentially affected. This is one that we saw early on in the pandemic as an issue, is that workers didn't know when they might be potentially infected, right? Like, I had dinner with my sister on Friday. She wasn't feeling well. She didn't get tested though until Saturday, but she was waiting for the results. So I still came into work on Monday. She gets the results on Monday. Employee starts to feel sick Tuesday. And so early on, employers were like, why'd you come to work? But people didn't know, right? People didn't know, well, what is exposure? What is the risk? When should I stay home? So that's having training for your employees, making sure they're educated as to, well, what are our policies? If you're around somebody who is not feeling well, do you still come to the workplace or not? And I would say probably not until you're pretty clear that you're not, infected. So minimizing negative impact of quarantine isolation. So that's just protecting people, right? So if they are sick, allowing them to actually take leave, paid leave if possible, flexible workplace. Isolating workers with symptoms, enhanced cleaning. This is following CDC recommendations. And this is another place where we've addressed with clients, right? If somebody's sick in the workplace, well, what do we need to do? And CDC definitely has specific requirements, but OSHA's new guidelines also go through, if somebody's sick and they've been, like, if I was sick and I'm in this office, what do I do? What do I do as an employer to make sure that people are being protected? And there's closing off the space for at least 24 hours. Making sure you disinfect it after it's been closed off for a period of time. And so there's specific requirements for that.
And I'll point out that the standard also has that requirements as well, but they track each other. Essentially, maintaining or being knowledgeable about the CDC recommendation is the best way to go in terms of following the standards and what's required in terms of the cleaning or what happens when someone tests positive at the worksite.
That's right. Yeah, CDC, Department of Health are all good places to go. And the workplace safety standards, I think, refer back to CDC, right? If you're following their recommendations, then you're likely in compliance with the Virginia workplace standards, right?
That's right. So the standard provides for the sort of the minimum borderline, but if you're if you're following the CDC guideline or industry standards that goes above the standard, then you're okay.
Mm-hmm. So a couple of the other things I wanted to mention for OSHA, just so people are aware that's a little bit different from the Virginia safety standards, is that now that vaccines have become available, OSHA has addressed that in their guidelines, saying that employers should provide vaccines at no cost to all eligible employees. And basically their approach at this point is allowing employers to encourage the vaccine. So their guidance says that employers should educate employees about the safety of the vaccine and the effectiveness, but it doesn't come out and say that employers should require it or that employers should push it or anything like that. And another piece to mention is not distinguishing between vaccinated and not vaccinated employees. So even if you have employees who have been vaccinated because maybe they're higher risk and they're in some of the earlier stages, they still have to comply with all the workplace safety requirements, like wearing masks, staying 6 feet away. And OSHA says basically we're still evaluating the effectiveness of the vaccine, and we don't know whether or not it's a silver bullet. Well, I think we know it's not a silver bullet completely, and so you still have to have vaccinated employees meeting these requirements at this point. So one other thing that OSHA says is that employers should provide all workers with face coverings, and this is different than what their stance in the past. They've declined in the past to require or recommend that previously, but now that's recommended for employers to actually provide face coverings for their employees. And then I've kind of alluded to it, but if an employee has issues with wearing masks in the workplace, you do have to address reasonable accommodations. One example that's been in the news recently is Nike has agreed to provide its employees with transparent face masks so that deaf and hard of hearing customers are able to still frequent their stores. And that's not an employment necessarily accommodation, that's more of a public accommodation, but that's the types of things, if somebody has breathing problems or, a breathing condition, they may not be able to use the same types of masks as other employees. And so you have to be able to address that with your employees as well. As I mentioned at the beginning, President Biden has directed OSHA to look at whether or not emergency temporary standards should be implemented by OSHA on the federal level as well. And that's expected to come out by March 15th. So those are the sort of legal requirements for employers looking to bring employees back to the workplace or having, a cohort of employees back to the workplace that we currently have, and some updates. Sara and I wanted to address some of the more practical considerations as well of things that employers have been asking us what they should be considering when bringing employees back into the workplace.
Right. So one of the issues that came up a lot in the past couple of months has been the vaccinations. Can the employer mandate vaccinations in order for the employees to come back to work? And the simplest answer is yes, but it's very nuanced. The employer has to have a business necessity justifying the requirement. And the threshold is that is the employee without vaccination pose significant danger to himself or others. The most easiest sample of where the employer can require vaccinations would be, healthcare providers. That would clearly, it's very obvious that if you're not vaccinated, you could pose a significant danger to himself or obviously infect and pose danger to the others. For a lot of the audience here, where most of the employees has been working remotely and have been successful, our answer is probably, maybe, and a very questionable maybe, in a sense that what justifications can you give and business necessity do you have to mandate all employees get vaccinated? So before you go down that sort of rabbit hole, consider the job functions that you have, and consider the company's operations and why you think that the vaccination is necessary. And once you do decide to go into the mandate or require the vaccination, then you have to consider the legal implications of ADA, the Disabilities Act, because if you are having a vaccination screening questions, then that's considered that implicates ADA, and therefore you have to have a job-related necessity. Again, this goes back to what justifications you have, what job necessity do you have for requiring the vaccination. And you also need to consider what accommodations you need to provide if an employee has a pre-existing illness that creates adverse risk to the vaccinations, or if they have a religious objections to the vaccinations, what type of accommodations can you give to those employees? That's what sort of the things that you need to consider before you make the decision that all employees requires vaccinations. You also need to consider current vaccination availability. Right now, this government is putting in priority list, and so how are you going to address employees who are able to have the vaccinations on a priority basis, and when the others are able to get the vaccinations, and how are you going to implement that as they roll in the employees to come back to work? And how are you going to implement that mandate? By incentive-based, meaning giving them the days off to get the vaccinations done, give them additional PTO to accommodate for that, and what would you do if employee simply refuses, not just because they have religious objections or health reasons for refusing to get vaccines, but just generally refuses to get vaccines? What are you planning on doing once you do decide to mandate the vaccinations? So generally, in office settings or employers who has a lot of has been able to function remotely in the past year, I think Marina and I have both been generally recommending not to specifically mandate vaccinations, but going to the route of education and encouraging vaccinations, but not go to so far as to require them.
Yeah, some of the questions I'm starting to get now are, I do a lot of work with government contractors too. So if they're on site at the government, what if the government mandates vaccines in order to, to be on site, or other customers or vendors? I think a lot of people are still in the sort of wait and see mode, because there's not, even though EEOC has come out with guidance and not saying that saying that it can be legal, basically, even though it's guidance, and there's case law. I know Sarah's familiar with, where there's other types of vaccines that have been mandated in like healthcare industry. It's not generally accepted yet in the workplace. So most employers are sort of wait and see, considering maybe having people come back after vaccines are available, but allowing people to stay home if they don't want to get a vaccine. And so there's definitely a lot of talk right now as to what people think is reasonable and not just legal. So one other thing that came up and has come up and was mentioned at the beginning is, what liability there is, right? What if people are coming back to the workplace and they get sick, am I going to get sued? Am I going to, have to go through this long legal battle over the COVID? And so early on, employers were asking about having liability waivers. So if you want to come back to work, we want you to sign away any liability, assumption of risk. In general, Virginia has a public policy against these. They're not enforceable unless they're very specific. And so that requires you basically to say, if we are negligent and do not provide you with a safe workplace and you get sick and die, you won't hold us liable. And so most people have not gone that route, and it's likely not enforceable. To me, it's inconsistent with your obligations to provide a safe workplace, right? I mean, instead, you want to be telling your employees what we're doing to make it safe, why it's not, you know, why you should come back to work and why you should be comfortable with that decision. And then if you require somebody to do a liability waiver before coming back to work, obviously they could say, no, I don't want to assume that risk, so I'm not going to come back to work. And that gives them the discretion to decide whether to come back, when most employers, once you're calling people back, you really need them to come back and want them to come back. So what we've seen as alternatives are acknowledgements. So more along the policy realm of, these are the policies that we've put in place. These are the requirements of you. You have to self-check. You have to stay home if you're sick. We're asking you to stay away from people. We're asking you to wear masks. You acknowledge that these are required for you and your, you know, your coworkers' safety, and you're required to abide by it. And then if they don't abide by it, then that gives you a policy reason for terminating or making, you know, disciplinary decisions. Workers' compensation. Workers' compensation normally relates to work-related injuries and accidents and diseases. So it could, in theory, cover COVID-19. You know, with community spread, it's hard to prove what is a work-related injury or accident. OSHA came out with some guidelines. You do have to report it if you think it is a workplace injury. I keep saying injury, but, you know, workplace contracted disease. And that requires you to look into it, you know, what the exposure was. Does was somebody sneezed on by somebody in the workplace? And likely it's more unclear than that. So workers' comp may cover it. In Virginia and other states have already passed these types of laws, but Virginia is at least considering passing a law that would amend the Workers' Comp Act that would cover at least high-risk workers. So teachers, healthcare workers, if they were to contract COVID, it would be covered by a Workers' Comp Act, which candidly, employers usually want it to be covered by workers' comp, right? Because that is all-inclusive. That's the only remedy for workplace injury. And then, you know, if it's not covered by workers' comp, potentially you might be sued for like a negligence action. You could look at your general liability insurance and see if you're covered under that insurance. So as you're upping your insurance, if you have renewals, make sure you're reading what's been changed, because insurance companies may be trying to exclude it at this point, so that they're not covered if it's a COVID-related disease. We are kind of getting close to, I think, the time at this point. So I don't know if we want to see if there's questions and go from there, or go through the other slides. What do you guys think?
You do have a few questions in the chat as well in the Q&A.
Okay. Well, let's just address, there's only a couple of questions that I see. So why don't we address them, and then we can move back to the slide if we have time.
You're almost done. So.
Yeah.
All right. Okay. Do you want to do the questions first then, Sarah?
Sure. So I see one question. Let's see. Has the 24 asymptomatic period been changed from the original 72 hours? I think that is referring to the standard, when the employee needs to be excluded or may be the return to work after isolation, if I'm reading this correctly. So yes, so originally under the emergency standard, they had a requirement that the fever has to be gone for 72 hours without the help of fever-inducing medication, and that has been changed to 24 hours under the standard. So yes, that has changed, but again, there's three categories you have the employee has to satisfy in order for them to be eligible to come back to work, and that's one of them is the fever. But the other two, at least 10 days since the onset, and there's an improvement in the respiratory symptoms also has to be met before they can come back. Then. Let's see.
Looks like there's a question of some employers are compensating employees for taking the vaccine. What information do you have on that? And so there definitely are, different larger employers that have made it publicly known that they're going to provide, bonuses. So if an employee gets a vaccine, they'll give them $100 as a bonus for that. That's an incentive. I mean, from a legal perspective, that's not a mandate, right? They're not mandating the vaccine. I don't see any legal issues with offering incentives. There is, as far as workplace health and safety, like if you're going to have your own health and welfare fair where you're going to offer the vaccines and encourage people to take them through that, there's an employer group of a lot of employer groups who've asked EEOC to actually weigh in on whether or not that's okay. And that's based on the fact that EEOC in the past has highly scrutinized health and welfare programs. And so they want to make sure that it's okay before they actually implement that. So that's something I think EEOC will come out with more guidance in the coming weeks, coming months on employer health and welfare programs that relate to vaccines.
And I see, is there a privacy issue of acknowledging who in the office has been vaccinated? Yes, you have to maintain the confidentiality of the individuals who's been vaccinated. That shouldn't be acknowledged in the public, publicly. It's part of the, ADA and HIPAA requirement. So.
Yeah, in general, the ADA confidentiality of medical information applies regardless of whether the person's disabled. So if you're receiving medical information about employees, especially if it's somebody like your HR person, right? If they're talking about it openly, I mean, they don't have confidentiality, but if they're telling it to your HR person, you have to maintain that confidentially.
Right, and that also includes, like if we talked about under the OSHA requirement as well as the Virginia Workplace Safety Standard requirements, this self-screening for the employees. Are you having someone, you're keeping track of the individuals or the employees, temperature, for example, on a daily basis. That information also is covered by ADA, so that needs to be segregated and kept confidential as well. So.
I think that's most of the questions. Some of these slides, just to go through very quickly, I guess, is that obviously communicating with your employees is very important. We've kind of mentioned it throughout as sort of legal guidance or legal suggestions, but providing your employees with information about what you've done to make the workplace safe is sort of the first step, right? Because people might have a lot of concerns coming back to work, but giving them information about why they shouldn't be concerned is helpful. And then if they still maintain concerns, right, they may have concerns because of their own serious illness or a family member that they live with that's at a higher risk, or, for Sara and I both, it's childcare issues with either, schools being canceled, and for Fairfax County, there still are, how do you manage teleworking, coming back to the office? So opening up the line of communications with your employees, early and often is what we've found to be helpful, so that okay, well, who are the people that have concerns and how can we deal with this? If we can do a phased approach back into the workplace, maybe we only have 25% people come back by June, and we let people self-identify as whether they want to come back or not. Those are approaches that you could take. My slides aren't advancing.
Here's another question about those who simply refused to get a vaccination. Or they pose an unnecessary risk and danger to other employees and clients?
I mean, at this point, that's not really an issue because the vaccine's not available, right? So, maybe at some point that becomes a concern. And I think that's going to be very fact-based, though. If we at some point get to herd immunity, it might be that one person refusing a vaccine doesn't really put everybody else at a huge risk. So I think those concerns are ones that aren't concerns right now, in my sense of where we are in the vaccine rollout and what kinds of arguments employers could make as to, direct threat and things like that.
Right. And they also, again, it's really factually based. So if all the other employees, and if that employee has no client exposure and all other employees at this working site are not have gotten vaccinations, then, could it possibly be considered unnecessary risk and danger? Probably not. And if the employee is, working remotely 100%, then certainly I think it's hard to argue that they are unnecessary risk and danger by just simply refusing to get vaccinated. So it's very factually based.
Our last slide was just other things that you should be aware of or be keeping an eye on is things like other leave entitlements such as FMLA or state paid leaves that might be covered when people have COVID related illnesses or needs for leave. DC has a COVID-19 Support Emergency Amendment Act that actually expanded the DC FMLA and accrued sick and safe leave to require paid leave up to 80 hours, which is similar to FFCRA for COVID related leaves. And then also if childcare issues, you're covered by DC FMLA for unpaid leave. So for employers in our area, we're in the Northern Virginia area, obviously there's Virginia requirements, but then if you have employees working in Maryland or DC or other states, you need to be aware of what those requirements might be because they may differ. And some of the things that we saw early on were different executive orders that were coming out with travel restrictions. And so I had clients that had work locations in Delaware, Maryland, Virginia, West Virginia, and they might have like a regional manager who normally would go to different stores to check in, could that person travel? And if they did travel, were they going to have to quarantine in Delaware for 14 days before they could come back? And so keeping apprised of, any executive orders in the other jurisdictions in which your employees might have to work as well. And then the last point was just coordinating with others, right? Your contractors or clients. I kind of mentioned this with the government contractors, but if you have temporary workers coming in, your staffing agencies, if you're an actual staffing agency, making sure that you know what your clients' workplace safety standards are, making sure that your temporary workers are aware of them before they go in and they're willing to comply with them as well. So.
All right. Did we get to all the questions in the Q&A? What if a healthcare worker refuses a vaccine?
I think that's an employer, employers may or may not be mandating it at this point, right? So, if the employer's mandating it, could they decide to say, well, you have a period of time in which you can get that vaccine or else we're not going to hold your employment open. I think some healthcare workers are being subject to that, right, at this point. I don't know that all of them are, though. I don't think all healthcare workers are being mandated to take it at this point.
Okay. I think that's about it in terms of questions. One last one was, are you going to make this presentation available?
Sure.
Okay.
Happy to do
On our website, and we'll make it available through our website as well. I put my contact information in the chat for anybody who needs to contact us directly. I want to thank Sara and Marina for this unbelievably detailed presentation. There's a lot to this, obviously, the devil's in the details, so to speak. So really, I would encourage anyone who has really specific questions to reach out to Sara and Marina with OFP, I'm sorry. And thank you all for participating, and thank you for the presentations.
Thank you.
Thank you.